Great. Good afternoon, everyone. It is a great pleasure to welcome you all to our Amsterdam Center for International Law ACIL lecture with Eric de Brabandere, who will speak today on the history of arbitration during the Cold War. Well, we're very happy and fortunate to have you, Eric. Eric is a leading expert in the practice and theory history of dispute settlement more generally, in particular of arbitration. He's a professor of international dispute settlement at the University of Leiden around the corner, where he also directs the Grotius Center for International Legal Studies. He is the editor-in-chief, together with me, at the Leiden Journal of International Law, and holds many other advisory positions, because everybody wants to benefit from your experience and from your knowledge. So it's without much further ado, really, without any further ado, really, Eric, that I would want to invite you to deliver your ACIL lecture on arbitration during the Cold War. Thank you so much for speaking to us, discussing with us. We're recording this first part of your lecture and then stop the recording for a Q&A off the records. Eric.
Thanks, Ingo. First of all, thanks very much to you and the Amsterdam Center for International Law for inviting me. We're indeed around the corner, so at least in theory, not for the moment. But thanks very much for inviting me to share my thoughts on investment law and arbitration during the Cold War. It's really a pleasure, and also I find it a great honor to be part of this lecture series. So many thanks, and also to see so many of you participating here. So what I'll do today is, and it's based on my contribution to the Cambridge History of International Law volume, that is a relatively important project to which many of you are also participating, I know. And the idea is to retrace a bit everything that happened during the Cold War in terms of development of investment law and arbitration. Now, it's a very difficult exercise, I thought myself, not only because generally writing about history is, I think, a tricky exercise, but also because it's a very heterogeneous period. The early Cold War, immediate post-World War II, is very different from what we saw towards the end, 70s and 80s. So it's not a very linear period in which you can actually see very homogeneous or linear development of the law of foreign investment. And you actually have many different aspects that relate to investment law, arbitration, that occurred very much in parallel. And sometimes, and this is one of the things I will also point, there are quite some paradoxes in how things have developed, which I will try to explain, or at least given a first idea of how we can explain the paradox and the antagonisms. Because this is the second important point, is that you see that many contestations in certain fora were actually, or occurred in parallel to the acceptance of yet other norms that were very similar on, for example, at the bilateral level. There's also, of course, what is called what I call implicit chronology, and I take this also from the editors of the Cambridge History, Sundhya Pahuja, Gary Simpson, and Matt Craven, to give them some credit. There's, of course, in all discussions on the Cold War, sort of implicit chronology that ranges from the immediate post-World War II towards decolonization, then turn to capitalism, and perhaps also bilateralism, which is permeates throughout my discussion. So the idea is also to focus on some overarching claims that I will try to make or explain, at least, aside from the sort of more themes-based focus. So one of these conceptual elements, aside from the ones that I mentioned, is that the Cold War period has often been described, of course, as a period of rivalry between the East and the West. And this analysis actually shows that it's not so much the East and the West rivalry that has shaped the development of the law of foreign investment, but also, and perhaps more importantly, North-South discussions following from the decolonization itself. So the decolonization had quite an impressive impact on the law of foreign investment during the Cold War. We cannot, of course, completely forget about the East-West rivalry, because this, of course, played a role, but it's perhaps not as important as one might think at the very start. Another element is that we often also have a tendency to see the Cold War as really a politically high dense period where the East and the West were really fighting on the political sphere, and that there was not so much international law involved. But especially in relation to the law of foreign investment, you see that this was actually a very important period where much of what we now have was actually based on discussions, at least during the Cold War. So it's a period of what I think is really impressive lawmaking, but also attempts at lawmaking. And then finally, and this links a bit with the implicit chronology I mentioned, the turn to capitalism also coincided with a turn to bilateralism and an ensuing, but I leave a bit in the middle, whether it's actually a consequence of or really a trigger, of the bilateralism, the idea that the sort of legal technical aspects are completely detached from the broader political economic discussions. And this is quite interesting, I think, also. So I'll look at several themes, some perhaps a bit more in detail than others. And I think you have received a copy of my draft chapter. So much of the information that I will not cover is actually in there. So again, I'll base myself on themes rather than this chronological approach, because it's I think really impossible. But of course are very much linked. So we first have, of course, a period, especially in the early decades following the Second World War, of relatively important, not only in numbers, but in terms of significance, nationalizations. So this is a thing that started immediately after the Second World War, but then it was not so much related to nationalization of foreign investment. It was really sort of immediate post-World War II reaction to the occupation, collaboration with the Nazi regime, and also really purely financial and economic considerations of really starting the economy again after the Second World War, and the state, especially France, taking control over certain important areas of the economy. And then we saw, of course, starting in the 50s and then also in the 60s following, quite important nationalizations in Kuwait, Iran, and of course Libya, which is famous for the three important arbitrations that followed from a relatively single act, in fact. The interesting thing about these nationalizations is that they did sort of impact a bit the discussions that took place in the General Assembly, and I'll come back to this. But quite interestingly, these had not so much to do with decolonization itself. So, right, the nationalizations in Iran, for instance, in Kuwait, were not necessarily based on newly independent states fighting against or wanting to nationalize their assets because they had been granted by the former colonized states. And the same goes for Libya. The three major arbitrations, so Liamco, Texaco, Calasiatic, and then the BP arbitrations, they actually occurred in relation to concessions that were granted by Libya after independence, right? What groups all of these and what makes them quite interesting is that they all nonetheless really fit into the general narrative of sovereignty over natural, permanent sovereignty of natural resource. And really the idea that if you disagree with oil concessions in the sense that the terms granted have been too favorable, you have the right to nationalize and in parallel, of course, increase pressure to renegotiate these concessions or simply take over the concessions. So that's a quite important point. Legally, they're also quite relatively interesting, and specialists that are listening to me will know this, of course, that some of them sort of paved the way towards what was called the internationalization of contracts. So the idea that concessions, even if grounded in the domestic law of one state, also because usually they included provisions that extended the applicable law to also general principles of law, resulted in sort of internationalization of the applicable law. Right, so this is also quite important. If we look at it, I'll not enter into these more legal technical issues, but what is also quite important and makes the link to my next theme is that these arbitrations, especially the Libya arbitrations, they did actually refer quite often to the permanent sovereignty of natural resources discussions in the General Assembly. Right? So not necessarily endorsing, but referring quite often to these declarations, and they actually, as such, recognize the validity of the claims in the PSNR resolution. But, and this is a big but, they also at the same time sort of left the sanctity of contracts untouched. Right? So they did find that you could not nationalize or expropriate without any compensation. So this brings me a bit to the parallel development at the General Assembly and the permanent sovereignty of natural resources, the NEO Declaration, and then the Charter on Economic Duty of States. This is, of course, perhaps the most known discussion that took place in the General Assembly during the Cold War, looked at it from the perspective of perhaps economic law, dispute settlement, and arbitration. It's basically a continuation of the rather principled confrontation you had between Latin American states and the US, amongst others, in relation to the Calvo Doctrine. So it's a bit of a same domestic standards versus international standards discussion that gained momentum following decolonization and the massive increase in sovereign states, mostly from the South, of course, at the General Assembly. So this discussion actually was really internationalized in the General Assembly. And there are two reasons for this, I think. One is relatively simple, that as the number of sovereign states grew, they simply had numerically the majority in the General Assembly. But it's not only this reason that makes the General Assembly the sort of most obvious arena for the discussion, but also the political nature of the discussion. And this is, again, something that was abandoned towards the end of the Cold War, is that you see that discussions on the legal standards, the norms, were brought into a broader political discussion, which includes notably also the role of transnational corporations and principles such as permanent sovereignty of natural resources, which of course cannot be detached fully from the technical aspects of the law of foreign investment and the standards of treatment, etc. Right? So this is quite important, and this also showcases, I think, the discussion in the General Assembly showcases that the discussion there was really more a North-South discussion than an East-West discussion. Permanent sovereignty of natural resources, NEO Declaration was really a sort of claim from the newly independent countries and the new sovereign states to change international law, or at least to foment international law, to cement certain norms according to what they consider to be the right approach. So I'll not enter into details on the declarations themselves. The Permanent Sovereignty Declaration, of course, slightly more nuanced than the NEO Declaration, if we look at the standards contained therein, notably because you had more references, for example, in relation to the compensation in case of expropriation. You had a reference to international law, right? It referred to appropriate compensation, but with a link to international law. You had the same for dispute settlement. And this was seen a bit as a compromise between North and South, right? And this was actually abandoned in the NEO Declaration, which keeps appropriate compensation, but refers not really to international standards, for example, but really to the domestic standards, to what the state considers to be appropriate compensation. And then you had, of course, the Charter of Economic Rights and Duties of States, and plan of action that accompanies it, which pretty much continues the line of the Neo Declaration, with an explicit rejection of the whole formula, the prompt, adequate, and effective compensation, for example, with again no reference to international law. Right? So this is again a sort of continuation, but a bit of a hardening of the debate, and you see the position of the states from the South and newly independent countries that actually took over and sort of relinquished the idea to compromise on certain standards. Now, without the sort of legal technical aspects, these resolutions and the whole debate is, of course, important for several reasons. And the first one, it shows really the absence of a general consensus at that time on the norms themselves. I think that's quite important, or at least the precise characteristics of the norm. I think everyone agreed that you had the right to expropriate, but then how do you implement it, which compensation? So this shows the absence of a consensus on this. And but secondly, and this is also quite important, is that you had, and I started by saying there was a sort of continuation of the sort of Calvo debate. It aligned pretty much the Latin American position with those from states in Africa and Asia, for instance, right? So you had a grow of the block of states that opposed what Western states considered to be the customary norms and the claims that these were validly existing at a certain point in time. So you had what Sornaraja explains, sort of internationalization of the Calvo doctrine, which I think is quite interesting also. And this, as I will discuss in a couple of minutes, was again gradually abandoned afterwards with the move to bilateralism. That occurred pretty much, not really in parallel, but there was a big overlap between the Neo Declaration, PSNR, and Charter of Economic Rights and Duties of States, and the turn to bilateralism. The second important element of the debate is also the role, as I said, of transnational corporations. And this is what I think is an important debate that is often overlooked, because the law of foreign investment was really discussed jointly with the role of transnational corporations, right? Not necessarily what rights they had, but especially the responsibilities and the obligations they had. So you had in the PSNR resolutions, the Neo Declaration, many references also to the role of corporations, and not only to the law of foreign investment, that is, in a narrow perspective, the rights that aliens, foreign corporations would have. So the PSNR resolution was a bit silent on the issue, but you see in the Neo Declaration, and especially in the Charter, that the role of corporations was increasingly present. And you had a relatively important set of norms that also related to transfer of technology, and quite interestingly and importantly, also control, to what extent states could control the role and the activities of transnational corporations when they act abroad. This, of course, Angie knows this quite interesting, is a bit paradoxical, because at one point you see developing countries claiming to have full control, permanent sovereignty of their resources, but also acknowledging that when you have transnational corporations, they are limited. That is, what developing states can do when transnational corporations act abroad also is to a certain extent limited, right? So they have to acknowledge that it requires regulation. And this, I think, is also an important point, this idea to join everything in one single instrument, which was also gradually abandoned. And interestingly, you now see researching in a couple of investment treaties since several years, and notably the Dutch new model BIT of 2019, which has a couple of interesting articles on sustainable development, but also on the role of corporations. Now, the United Nations Commission on Transnational Corporations came up with a draft, and as we all know, it was in the end never adopted. And the main reason was, of course, that discussions were protracted, and at a certain point, towards the 70s, 80s, in parallel to the rise of bilateral treaties, states lost their interest in a multilateral regulation, considering that you had, of course, these bilateral treaties which did the trick, and you had really a loss of support from mostly Western states who no longer saw the need to invest in a multilateral regulation. But it is the draft instrument they came up with is really impressively comprehensive. It's one of the most comprehensive you will find in the regulation of foreign investment and the role of transnational corporations, because it included precisely and responsibilities and protection of foreign investment, and precisely because of its comprehensiveness, this was probably also the Achilles heel of the whole project, is that it attempted, of course, to see consensus on so many different things that were in and of themselves, even taken separately, very controversial in the sense that they did not attract the necessary consensus. So all this, again, occurred in parallel to a rise in bilateralism, which started also, interestingly, relatively early in the Cold War period with, of course, first the persistence of friendship, commerce, and navigation treaties, which, as is known, of course, existed since many years, but have, after the Second World War, continued to exist, and then gradually sort of transformed in bilateral investment treaties. And this is due to several considerations. One of them, of course, is the fact that you had an agreement on the trade aspects, on the GATT, following the Second World War, which could justify abandoning all trade law aspects in friendship, commerce, and navigation treaties and focusing, therefore, mostly on bilateral investment treaties. But there is, of course, here also an overlap. It's not as if friendship, commerce, and navigation treaties ceased and then sort of were replaced by BITs. Late friendship, commerce, and navigation treaties look very much like early BITs. It's just a question of name. Our treaties signed by the US, the late friendship, commerce, and navigation treaties by the US really look very similar to the very early BITs. And the US was one of those states who relatively lately started signing BITs and stuck to its friendship, commerce, and navigation treaties. What is interesting here also is that when you look at bilateralism, there you see the East-West divide really coming back into the fore, especially in the US, because it's also heavily documented. There is quite an impressive political aspect to the signature of bilateral treaties. It really was used even until the 70s, 80s by some states, and notably the US, to show the adherence of the other state to the values of the United States, and I mean the economic values, and the sort of idea that liberalism, adherence to liberalism instead of the Soviet model. So this is quite interesting. Again, I'm not sure that you can extrapolate this to all BITs, but especially the US has really used BITs to at least show that there was adherence to the liberalism, economic liberalism of the United States rather than anything else. Again, in parallel to this, you had the emergence of BITs, and there is one, what I still consider a bit of a mystery, but Ingo is about to elucidate the mysteries, is the first BIT by Germany. And I know Ingo is doing some research on the reasons of Germany signing the first, what is generally referred to as the first genuine bilateral investment treaties. Bilateral investment treaty, it has, of course, perhaps something to do with the fact that Herman Abs has always been one of the proponents of signing notably specialized treaties with access to arbitration. But the reality is that at a certain point, but this started really slowly. This is also important. We have the impression that when we say the BIT started with Germany's signature, first signature of the first BIT, everything boomed. You really had to wait until the 80s to have a massive reliance on BITs. It was a really very slow start. What I'm interested in is also why states started to sign BITs while opposing, and I'm looking here mostly at developing countries, exactly the same standards at the multilateral level, which is one of the paradoxes of the whole period. There are reasons that relate to why states sign BITs, and then there are reasons why mostly developing countries adhere to these BITs. I mentioned already the idea that specialized investment treaties made some sense because trade aspects were regulated on the multilateral level. Then, of course, you had the idea that an investment treaty was necessary, interesting as a reaction against the nationalizations and the lack of consensus on the multilateral level. This is, of course, a very Western state developed country perspective. Another aspect is quite importantly, and also something I mentioned at the very start, the idea to depoliticize the whole debate. And here again, I'm not entirely sure whether BITs are a consequence of depoliticization or precisely one of the attempts to depoliticize the disputes, the discussions. But the reality is that the BITs themselves really deal only with the legal technical aspects of the protection of foreign investment, at least initially. And then, of course, you had the inclusion of arbitration at a certain point, which again is probably something that is an evolution and cannot be pinpointed as the result of one specific reason. Santiago Montt, for instance, says that it's really more of a historical accident, that there was at a certain point simply a transformation of interstate arbitration to investor-state arbitration, which also responded to the need or the perceived need to depoliticize the disputes, to bring them to a neutral forum, specially designed to settle that dispute only outside of any political pressure or interference by the state. And then if we look at maybe a bit more the reason why developing countries adhere to the system of bilateral treaties, I think there are two reasons that probably stand out. One of them is the promise of attracting foreign investment, and I'm really emphasizing the promise. As we all know, it's not a given that a bilateral treaty itself attracts foreign investment, but at least they were presented as such. And it's a reality that states still today, I think, believe that it is an important instrument in attracting foreign investment. And as states more towards the 70s and 80s, of course, were in need of foreign capital, foreign expertise, it was relatively logical when you, again, consider that the BIT is important to attract foreign investment, that BITs were in effect signed. Secondly, there is, of course, and this is the sort of implicit chronology I mentioned, there is a move to economic liberalization towards the 70s and 80s, with massive lobby from the World Bank, the IMF, and international financial institutions generally, in developing countries notably, with a massive push to have these states adhere to the system of bilateralism and more generally economic liberalism. Now, alongside this, but I'll skip this a bit, you had, of course, important attempts to multilateralize, and Stefan Schill, of course, the expert in the field, attempts to sign multilateral treaties, which failed. The most famous one is, of course, the Abts-Shawcross draft convention. It failed for various reasons, mostly because at a certain point they were also seen as a sort of Western proposal, but also because of bilateralism precisely. A bit similar to the whole discussion on transnational corporations, the idea of a multilateral treaty lost much of its relevance, especially Western states considered it no longer really necessary to engage a discussion, precisely because they had bilateral treaties that did exactly what the multilateral treaty would do. And it again also depoliticized the whole question. You brought it on the bilateral level without the whole discussions on a multilateral level. I'll finish off with one couple of things on the ICSID. Of course, the International Center for Settlement of Investment Disputes was created. Much has also already been discussed and explained in that respect. I think it's an important, not only institution, not only because it now, of course, deals with a massive amount of investment disputes. It's an important feature because this and the creation of ICSID is probably an archetype of the type of institutions that manage to be adopted by presenting it as a really technical question. And you see it, Taylor St. John wrote a whole book on the rise of investment arbitration, looking again at how the process, how the institution materialized and the discussions. But you see very much that it managed to gain support, interestingly, from many African states. 14 out of the 20 signatory states first were African states. By really lobby by ICSID and the international financial institutions, but lobby by presenting ICSID as really something that only deals with the technical aspects of dispute settlement and really does not engage in the protection of foreign investment, which is correct, of course, but also presenting it again as something detached from the discussion in the General Assembly on the permanent sovereignty of natural resources. And you had many African states that adhere to this system. It was also relatively clever of ICSID when they the World Bank, when they started discussing ICSID, to organize regional conferences, including the first one in Africa. So they really went to the states themselves to seek support for the project. Here again, you can wonder why. I think it has to do indeed with the quite impressive lobby of ICSID and the international financial institutions of which it is a part, of course. Question of process, including developing countries and notably African states. Latin American states were still very much opposed to the idea, at least at the very start, and since a couple of years again, if you can say so. You have to here also bring this into perspective of the turn to liberalism, which again prompted the idea to sign bilateral treaties, the promise of foreign investments, the need, or at least the perceived need, of a neutral forum to settle these disputes. ICSID was always presented as an ideologically neutral institution, right, that you could easily use to submit your disputes or to have your disputes settled without, again, any discussion on the contents of investment law, which was really one of the successes of the ICSID. They also, quite interestingly, lobbied quite heavily for the inclusion of arbitration clauses in treaties, because, and this is quite interesting, and it's discussed in detail by Taylor St. John in her book, is that ICSID's success, at least within the institution, was measured not by the number of cases, but by the number of arbitration clauses that refer to ICSID, which is something that you find, of course, not only at ICSID, but many arbitration institutions lobby, first of all, to have an arbitration clause with reference to that specific arbitration institution. And so they were really massively involved in trying to get ICSID arbitration clauses in treaties, because this proved the success of ICSID more than really having the disputes themselves. Because if you look at the first years after its creation, we all know that ICSID was not necessarily a very successful institution. You didn't have really so many arbitrations settled there. So all this to briefly conclude, again, a very heterogeneous period, very difficult to find a sort of linear development in the discussion. A period nonetheless where I think the foundations of what we now consider to be investment law and arbitration have been laid. They were not entirely developed then, but the foundations were laid, at least the bilateral investment treaties, which now of course boomed, but they were not so much, or they at least did not started growing during the Cold War, but mostly after the Cold War. Right. So perhaps the end of the East-West rivalry created the boost in bilateral investment treaties, but they were not so much the trigger of the signature of bilateral investment treaties. And then perhaps the most important point, I think, is that the whole discussion in the General Assembly, the decolonization, of course, is perhaps one of the phenomena that had the most important impacts on the whole discussion of the norms, even though with the move to bilateralism and the turn to liberalism, much of the debate and the perspective of developing countries was slightly abandoned. Is actually quite interestingly coming back also. And I said the final point, but I do have a final point. Sorry, Ingo. I think this idea to see it also as a question of, do you link the law of foreign investment to the political debate, the linking with the role of transnational corporations and the gradual abandonment thereof with a turn to bilateral treaties is quite interesting. And I added in the conclusion, you see this also in many states where BITs have actually not been signed by ministries of foreign affairs, but really by the sort of tax departments, departments of economic affairs, where you had specialists in economics and finance that deal with these questions rather than foreign affairs. And this is gradually, I think, reversing a bit, where you have inclusions of transnational corporations, responsibilities, broader questions of sustainable development, also questions of limits to expropriation that are being re-included and perhaps also being brought back to the broader political discussion, also with the recent discussions in Untitled, notably on reforms of investment law and arbitration. So I'll leave it here, and of course happy to answer any questions or engage in the debate